Most people think the courtroom is where your reputation lives or dies, but it's not.
It's the internet.
They get their news in the quickest way they can. Often it's by reading headlines on social media, Facebook, TikTok.
It's headlines, it's public opinion forming in real time, long before any facts come out.
If it's a televised trial, then it's different. And it was very different 10 years ago than it is now.
Your algorithm is going to be based on what you normally watch.
By the time the legal system even starts working, the damage is already often done, and people have decided for themselves, and cancel culture takes over. Question from a viewer in Los Angeles. I'm struggling with whether I should defend myself online or stay quiet.
If the gossip affects the workplace, then the employer absolutely has a duty to get involved as soon as they have notice. Today, we're talking about what happens when headlines replace facts and why clearing your name doesn't always clean up your life.
And soon, you'll hear directly from a special guest joining us again who lived it beyond the headlines.
Welcome back to the Glamorous Grind, where we break down the law and how it actually works for you, not how it's portrayed online.
This is not a gossip episode. We're not talking about who did what. We're talking about how the information is packaged and delivered as clickbait and crazy headlines.
We'll touch on how narratives form, how outrage spreads faster than truth, and why public opinion has become its own kind of courtroom.
And don't think this is something that only happens to celebrities. Social groups, social media, and professional circles can act in the same way. Let's get into it. Headlines are designed to provoke emotion, not to give you the full story.
Most people don't read past the headline, and once a narrative forms, corrections rarely travel as fast as the accusation.
And this is how partial facts become truth, and how public innocence and legal innocence become two very different things.
For real justice today, we're going to take a look at a clip from the Netflix documentary series Trial by Media, where they examine the effect of media coverage on trial verdicts.
I found out early on as a lawyer, it doesn't matter about the law. It's about being able to tell a story.
I mean, I definitely agree with him that it's not ever really about the case. It's about how you tell the story, and on both sides.
It depends. If it's a televised trial, then it's different. And it was very different 10 years ago than it is now. Because now people summarize news on social media. Young people don't listen to actual news directly from the source. I'm not going to offend young people because hopefully I'm still young too. But I mean, people are busy, so they get their news in the quickest way they can. And often it's by reading headlines on social media, Facebook, TikTok. Those with interest or political views can twist the story and narrative to be not what really the facts reflect if you go directly to the raw facts.
When you turn a courtroom into a studio, you have to turn reality into a story with good guys, bad guys, drama.
You've got to come up with ways to become part of the news cycle.
I'm not saying the trials are theater, but court of public opinion is very important. Because if everybody in the building likes these guys, they must be the good guys, right?
And the problem is your algorithm is going to be based on what you normally watch. So it's not like you have an opportunity to look at both sides. So if you are inclined to be to one political side or the other, that's what's going to come up.
Yeah, I mean, recently, for example, was an example. My mom saw a story on Facebook that some lady in my neighborhood got attacked by coyotes. She was in her 80s. She opened up the garage, and she had a little dog, and 6 coyotes were waiting and jumped her, and she ended up in the hospital. So then every day I speak with my mom. I now hear coyote attack stories because I think her algorithm is pushing that content to her. And I was like, be careful. Don't leave the kids outside in the playground. Coyotes are going to come. I'm like, Mom, it's the algorithm. I mean, it happens. Of course, those are real stories, but it's not as bad.
Yeah. There's a whole science behind it of the skip rate, what you have to put at the beginning of a video to make sure people don't skip through it. So a lot of times things will be pulled out of context, and those things will form people's opinions.
nobody had committed murder as a result of being on a trash talk show.
You used those people.
That's not quite the way I see it.
I wanted to kill those guys.
If it bleeds, it leads.
He'd raised me $500,000, so I made him a senator.
He absolutely embraced the media's attention.
You ain't seen nothing yet.
The NYPD shot someone 41 times. The media didn't have any interest in discussing who he was.
Everything was done for the purpose of ratings, and ratings are money.
I really wasn't sure that what I was seeing was real.
Stop the cameras. Let's stop right here.
I think what also helps form people's opinion is who is reporting and what channels do they watch, what reporters they watch to present the news.
Yeah.
Because everything is with the spin. I mean, when I was an undergrad and I was taking political science class, they had us watch different news channels to evaluate how politics are being reported. And I never paid attention to that before because I was 19 or 20 and I didn't care at the time. But when I wrote the report, I realized that it was reported very differently, different stories depending on who the reporter is, and people spin the facts. In fact, one of the channels at the time had a show that was called The Spin, right? Because they spin the facts. And now it became so prevalent, like every radio show you listen to, people interpret and argue over what they think instead of just getting raw facts.
Looking at the facts.
Nobody has time or patience to sit through the entire trial, right? If it's because everybody's got to make a living, and listen to every witness's testimony and then make an assessment for themselves. So when it comes to criminal trials, civil trials, or even family law matters, unless it's your own case, you're not going to be there the entire time listening to everything. And even if you are in court, you're only getting a piece of the story. And attorneys get to choose what portions of the story are they going to present, what's relevant, what helps their case, and what evidence are they going to exclude if it doesn't help their case. So you're still not getting the full story.
Right. I take a lot of cases to press if I find that they're, press worthy, if they really affect the public. I think it's important to let the public know that this is happening. But I always wonder if those cases do go all the way through trial and a jury member sits down, and they had seen the case in the press and the media before and they have their predetermined opinions. Can they neutrally evaluate the case based on the presentation?
They're going to be kicked off the jury panel because the judge or the attorneys will ask, is anyone familiar with the parties, with the attorneys in this case? And if they raise their hand, which they have to because they've taken an oath, and disclose that, even if they state they can be neutral, chances are one side or the other is going to want to kick them off, or the judge may disqualify them based on follow-up questions that may be asked by attorneys on that subject.
I think that cases in the media and the press definitely put pressure on the side that's paying, if it's a civil suit, to settle the case because they don't want that exposure. Because usually a plaintiff's attorney in a civil case isn't going to take a case to press unless it's juicy enough that, the press would eat it up. On PI cases, I've seen it a lot where the facts are kind of egregious, or if there's like a video recording that is kind of wild and the PI attorneys will take that to press, or if it's like involving a school or children, like anything that really affects the public. But I have seen pretty regularly that when those cases go to press, they resolve much quicker. On the employment side, if it's a private entity, I do think it encourages settlement quicker. If it's a public entity, not necessarily, because they just don't care.
But on another hand, if you are going to press against the public or private entity and they feel on the right that your statements and your client's position is not really what happened, they're going to fight all the way to protect their reputation in the community and in front of their employees if they're being falsely accused. So it could motivate them more to stand up for themselves rather than settle.
Potentially, but sometimes it's usually when cases go to press, they're pretty egregious. Usually most cases that aren't that egregious don't, like, if there's no evidence.
Well, it has to be interesting and have sexy facts, right? Because otherwise nobody's going to care.
Yeah.
There are a million cases being filed every day. What's so special about the cases being taken to the media? The ones you went on, press conferences, they involved public entities and discrimination that affect gender, right?
Yeah.
Gender discrimination. So that's different. That is an issue of public interest. In family law matters, people don't go on TV to talk about their problems unless they end up on a talk show after the case is closed or during the pendency. But you have to be mindful of what you say, because if you have children, your case is going to potentially be before the judge for the next 18 years if anything happens, and anything you say could be used against you if you don't choose your words wisely. If someone makes false statements that are untrue, then you could face a defamation lawsuit. And defamation comes in two forms, right? Written defamation or spoken defamation. So untruths, libel or slander.
I find in employment cases, a lot of times, the clients that I represent have either been fired or the work environment is so hostile that they've been forced to resign. And when they come to me, they're pretty defeated. And I have found that a lot of times this opportunity to kind of tell their story is empowering. So I appreciate that part of it, because most of my clients who I represent do feel that they've been very wronged and they feel their story hasn't been told. So
I have clients who felt wronged also by the family court system. I see them seeking out to others in similar situations on Facebook groups or other support groups. The sensitive part is that a child is involved. And the moment that gets out there and becomes public, then the child could be ridiculed in school. Other families will know what's happening. And a matter of private family issue, that's generally a matter of public record. Anybody can go to court and copy all the pleadings, declaration, all the trash talk people put in the pleadings. But when you make it public on television, then you really highlight that, and it invites curiosity in people to go and read what's been filed publicly, but relatively privately, because nobody cares until you make a big deal out of it.
Right.
We had Blake on our show, and he helped sue Child Welfare Services in the past. Again, those are cases where children get hurt because of someone's neglect, whether Child Welfare Services or the parents. And the story is told when it's too late, when the child is injured. In family court, a child could be injured because they may be taken away from a parent in a standard proceeding, not involving Child Welfare Services at all, but because the decision, let's say, wasn't in the best interest ultimately, although what the evidence that the judge considered, that the judge had available at the time, made the court find that that wasn't a child's best interest. So what I see people do is they return back to court very often to try to change the orders to communicate to the court that, hey, I have this new evidence. Something else happened. That's another piece of evidence you could use against the other side. How do people express their frustration if they cannot get relief in family court and they can't just afford to keep hiring a lawyer to go back? They express it on social media. When it comes to posting what happened in court or talking about the other side, if they hate them, when it comes to custody proceedings or their divorce, they're going to make it worse than it really is. So you got to look at it through a lens like, hey, don't take that for what it reads, okay? There is a different side to it.
I always warn my clients, both for personal injury and employment, to not post too much on social media, because all of that can and will be used against them.
We have it on our retainer contracts through Antonio Miranda that, hey, don't post anything on social media, because it can be used against you in family court.
Yeah. And it's like, even if you, like, let's say you're an employment plaintiff and you're saying that, you lost your employment and now you're super depressed. But then maybe you go on a family vacation and there's a picture of you, like, smiling in Hawaii with your kids. And they're going to find that picture and they're going to say, see, she's lying. She's not unhappy. She's not depressed. She's in Hawaii having the time of her life.
It happens in personal injury cases.
Yeah. It's important. We always tell our clients that the defense will probably hire sub rosa investigators to go take videos of them and spy on them, which they have a right to do, to see what they're doing in their free time. And you know, it's very hard for me to balance. I would never tell my client to like lie and put their life on pause, like don't go to the gym because you're claiming your neck hurts.
Of course you would tell them not to ever not go to the gym.
But like if they felt like they wanted to go to the gym for their mental health, even if their neck hurts or whatever, I'm like, okay, just make sure you know this is going to affect the value of your claims, because there's probably going to be someone in the corner of the gym taking a picture of you.
I think that people deserve to try to do things they enjoyed, and give it a shot and see if they can do it or not. Because the goal is not just to get compensation, but also to get back to your normal life and be happy.
Now let's do red flag, green flag, but this time for information consumption.
So we have a green flag and a red flag. If it's true, then I'm going to raise the green. If it's not true, Mila is going to raise the red flag. And if we disagree,
which sometimes happens, rarely,
both raise them and explain.
Scenario 1, forming strong opinions based on a headline alone. Red flag, for sure. The headlines are just that, headlines used to grab attention, and you cannot form a strong opinion without looking at all of the facts objectively, critical thinking, and the headline is never going to provide sufficient information to give you a strong opinion, in my opinion.
I absolutely agree. And if you really want to test it, because it's so easy nowadays, just take any news story from Reuters, pop it into ChatGPT and say, hey, this is my political view, or this is what I think. Can you write a heading for the story to reflect my opinion? And it'll give you multiple versions of the headline that you will like, or you can tell it now, make a headline using the same story for the opposite viewpoint, and it'll give you that. Scenario 2, asking, what do we actually know and what's still alleged? Of course, that's important. You have to ask questions to know the full story. That applies, I think, in a business setting or anything you see on the news. When you listen to one person telling you something, it's usually one-sided, and it can get you all hot and upset. But then you listen to the other, and you may feel stupid because you're like, oh my God, I didn't consider all this. They have a point. Now I have questions for the other person. And that's what judges do in court, right? They listen to one side. They're supposed to be neutral and not reach an opinion or conclusion. Then listen to the other side, not reach a conclusion. Give the other side an opportunity to rebut. Give both parties an opportunity to rebut, and then make an informed decision. That should probably happen in real life too.
I agree. I think it's absolutely critical to not only look at what's alleged, but what has actually been proven. Especially because in a lot of cases, a lot of things are he said, she said. And realistically, when I used to represent employers, I told them, anyone can allege anything. The question is, what can you prove? And sometimes it lands on credibility of the witnesses. If one witness is very credible, their allegations may hold more weight if the other witness is not as credible. So you really have to, especially if you're making an assessment, you have to look at not only what is being alleged, but what has been proven.
And also, who is alleging it and who is repeating something that was alleged by someone else. If you're, for example, reading a girlfriend's text message to her boyfriend, she may be arguing with him and telling her side of the story. If she doesn't show you his response, or he doesn't write his entire response back, then you will form an opinion based on what her story is. And in court, if someone brings in a text message from themselves to someone else, or text message between different people, often that's going to be considered hearsay because it's offered for the truth, meaning that you're using a text message from someone else or between other people who are not present, who don't have first-hand personal knowledge of what happened. They're just repeating something someone else told them. You're trying to use that as proof that something actually happened. That's what hearsay is, and it will be excluded. You have to have real evidence, either directly from the witness or through photographs, videos, whatever it may be. So see for yourself, right?
I think one important thing that I want to talk about is how we face this in the employment context all the time. In order to have a wrongful termination, an illegal termination, you have to be terminated because of a protected class or a protected complaint. Oftentimes we run into cases where there are some performance issues, and we're alleging that the termination was not because of the performance issues, but was actually because of a protected class or a protected complaint. Like, let's say my client is disabled and we think he was treated badly, and maybe given performance issues because he was disabled. And then, the fact finder or the jury has to decide, was the termination because of what is alleged, which is the disability, or were the performance issues separately? Was this person just a bad performer? Because California is an at-will employment state. So if you terminate someone because of performance issues, that's okay. But if you terminate them because of a protected class or a protected complaint, it's not okay. So that's one of those situations where we look at what is being alleged, that he was terminated because he was disabled, or that his disability was at least part of the reason for his termination, a substantial motivating reason. Or is that not actually accurate? Has that not been proven? And he wasn't terminated wrongfully. He was actually terminated because of performance issues, and what has been alleged has not actually been proven.
Scenario 3. Assuming silence equals guilt from celebrity accused of misconduct.
I think that's a red flag.
I agree. And often celebrities don't want to comment because if they have a criminal case pending against them, or potentially that could be filed against them, any statements made would be used against them. So there's no point to go make public statements that the prosecution will use against you. So when it comes to celebrities, it is different than when it comes to the courtroom. In courtroom, we have an evidence code that presumes that you're admitting something because you're silent. So admission by silence. Versus for a celebrity who may be faced with contract cancellations, potential criminal charges, it's often better not to make things worse in the media or provide additional evidence in the public forum that could be used against them until the time is right. But if it's really damaging to their reputation and there's no criminal case pending, it's just a civil matter, I think absolutely defend yourself, always protect yourself, and tell your side of the story. Because if you don't, the other side's story will influence your reputation and potentially cause financial harm.
From a human perspective, whether it's a celebrity or not, I think it's often highly undervalued that divorce is like a little death. Like you're mourning like the family that you built and that you established. And a lot of people may not want to say anything about the other person. They could be upset, they could be hurt. Even if that person is saying things about them, maybe they feel strongly and don't want to respond. So, everyone has very different personalities, different paths in life, and maybe their silence is just because of their own internal feelings towards the situation. I think you can never really assume that silence means admission or anything like that, because you don't know what's going on inside their heads.
Absolutely. I think there's a difference between a criminal case or potential criminal charges that may be filed against any person, including celebrities. If that's a risk, then of course remain silent. Do not text anybody. Do not post anything on social media. Do not speak to the media or anyone about what happened except for your criminal law attorney to protect the confidentiality and give you advice. And then you have to wait out until the statute of limitations to bring a criminal case against you passes. That's for criminal. For civil matters, if it's a contract dispute or defamation, anything else like that, I think you have to stand up for yourself, because media will be all over it if it's a matter of celebrity. Your fans will be making assumptions. You may lose fans. It will impact you financially. So you have to balance the story and tell your side before you get to tell your story and defend yourself in a jury trial. But in a family law matter, in a divorce matter, whether you're a celebrity or not, but especially for celebrities, media will not leave you alone if you keep talking about your divorce matter. And our office has represented many celebrities, majority of whom choose to not speak to the media, to keep things confidential, even when the other side may be going to TMZ and other places and talking bad about the other side. Because if you keep going, every comment you make, you'll just be constantly in the media. Maybe it's good because it may get your ratings up. Recently, I've seen a lot of posts on Instagram, I don't know why, about Victoria Beckham and her daughter-in-law and how they pose in pictures. But I'm like, you know what? It seems to me they're exaggerating it, most likely, because they have a documentary. You'd have some drama, make it spicy, get attention. It'll get you more ratings. But I'm a little bit suspect there because it's still a family. It's not a divorce. And it's a way to make money versus the thing in a divorce proceeding, especially when you have kids. I'd say stay quiet because when your kids grow up, they're going to Google things, and
Even
now with AI, things are going to come up.
If they're in school and they hear people talking about it, I mean, imagine what position that puts the children in.
Right.
That's awful.
Because children will feel embarrassed. They'll start taking sides and have to go to therapy over things that are avoidable.
Yeah, I agree.
Okay, now let's get gritty. Oh, man.
Okay, pick a question.
This is... All right, let's fold this. Okay, question from a viewer in Los Angeles. I'm struggling with whether I should defend myself online or stay quiet. About 2 months ago, a situation at my workplace blew up and turned into rumors that spread way beyond what actually happened. I won't get into what the rumors are, but they're not true, and the company knows they're not true. Someone posted about me in a local Facebook group, and then it got picked up on Instagram and Reddit. A lot of the details people are repeating are either exaggerated or just flat out false. Repeat, it sounds like defamation. I haven't been charged with anything. There is no lawsuit and no official investigation that I know of. But people online are acting like the facts are settled. Friends have sent me screenshots of strangers calling me names, speculating about my character, and saying things that could affect my career. I've stayed silent because I was told that speaking out could make things worse legally, but the longer I stay quiet, the more it feels like people assume I'm guilty. I've lost work opportunities, and I'm terrified this will follow me forever. Should I be defending myself online when people are saying things that aren't true, or is it staying silent that's the safe move?
Oh, my take would be like, if it's affecting his current workplace, for sure put in an HR complaint about it so that they can start an investigation and figure out who started the rumors if it's not known, or at least fire the person. In terms of, defending themselves, I would say, generally speaking, there are going to be haters, and anything they put out there will be used against them and can be turned around to look like they're lying or are being inaccurate, overly defensive. So I would just be very cognizant of that and tread lightly. I would for sure, probably if it was me, want to put out some statement stating very vaguely that, I deny all of this. None of this is true. There's been nothing to prove this. But beyond that, I'm sure there's a ton of things that they can respond to. I wouldn't go into any facts or details, especially because if it later turns into a defamation lawsuit or anything like that, you don't want to put anything out there that, sometimes silence is golden.
So you initially mentioned that the person that started the rumor could potentially get fired. So does that mean that employees can get fired for gossip?
Absolutely. Usually most companies will have a policy on that. And if it's creating a hostile work environment, absolutely.
How is an employer supposed to document the gossip and who it came from and how it spread when people who are generally involved in gossip don't want to actually gossip about those involved in gossip on a specific subject?
If the gossip affects the workplace, which it sounds like it is, it sounds like they're, losing on job opportunities because of it, then the employer absolutely has a duty to get involved as soon as they have notice. As soon as the employer finds out, they are required to investigate and look into it.
What would be considered hostile work environment because of the gossip?
It's all, arguable, clearly. It's he said, she said. I would say it's better to report than not. It sounds like this is a pretty serious situation. If it's taking off on social media that intensely, it's probably very egregious, whatever is being alleged. So I would say it would probably be sufficient to create a hostile work environment, because there are conflicts between employees all the time, and HR doesn't need to get involved in every conflict. But if this is so bad, if the rumors that are being spread about this individual are so bad that he is losing work opportunities because of it, I would say it absolutely is affecting the workplace in such a way that it should be investigated.
Well, I think it's also an issue whether it's true or not, right? Because if gossip is true, when it's something so bad.
I actually had a case where there was an allegation that, two individuals in a company were having an affair, and we made that allegation in our complaint. And my client was still employed with the company at the time, and there was an internal investigation that my client was spreading rumors because this was in his complaint. And there was an investigation. We had to speak to investigators, and the rumor was pretty undoubtedly true. It was proven. A lot of people had witnessed the affair, but my client was still had to go through that entire process. I can't disclose what ended up happening, but it was investigated, and notwithstanding the fact that there were, numerous points of evidence showing that the affair actually was occurring, it was still an issue.
In terms of defamation, wondering whether the company could be liable if the employee starts a rumor that's defamatory, per se, meaning it's something that accuses someone of being a criminal or having a sexually transmitted disease or something like that, that's automatically presumed to carry presumed damages, without you having to prove your damages, if it is false. And then it spreads everywhere else, starting with someone at the company and then others. Would the company be liable if the person who started the rumor got sued and it's false? I'm thinking that, and I'll let you answer in a second, sorry. I'm thinking that if a company does the investigation and terminates the person if it's false, right, then they would not be liable. If that person is employed, would that even matter? I think the litigant would probably still sue the company and the person, and then the company may have to try to file a motion for summary judgment or be dismissed somehow, because the statement wouldn't be made on the company's behalf. The statement would be made by an individual, right?
So a company can be liable for the actions of a supervisor if they're acting in the course and scope of their job at the time that something happens. So, some contexts I've seen this, if there's a sexual assault at work and the supervisor they're on the clock or they're at a conference and, sexually assault someone, the company might be liable for that under vicarious liability, superior respondeat. But if it's a statement made in their private time, they're not on the job, they're not acting in their supervisory role, the company will likely not be liable. Now, with that said, there are certain claims that you could bring against the company for negligent hiring, negligent supervision, negligent retention. If the company knew this person, had this, style of spreading lies and didn't fire him, for sure, you would probably bring claims against the company for hostile work environment, harassment, failure to protect from harassment. If they really didn't get jobs afterwards, you could bring claims against the company for failure to prevent retaliation, because to the extent you're not promoted because of something that happens that's harassing, potentially that could be a retaliatory failure to promote. I think generally speaking, bringing a claim to the media and to the public could go either way. Sometimes it helps push things along and get the plaintiff's voice heard, but sometimes it could go the other way. If the plaintiff is, a lot of times when plaintiffs go to press, they're perceived as someone trying to make a quick buck.
Well, I think, look, when you think about celebrities, usually it is the attorneys representing the celebrities who make statements to the public on their behalf, so it doesn't come directly from their mouth and can't really be used against them, although it depends. You either have a lawyer or your public relations person speak on your behalf. For general public, you are not going to hire a lawyer to make comments on your behalf on your social media, Facebook, or Reddit, wherever it may be. you're going to speak for yourself. So you have to be careful what you say, because you're not a trained professional, and you're emotional because it concerns you, and you're upset that these people are making false statements or exaggerated statements. Because even when facts are true, somewhat, if it affects you, you may still be defensive. If you find 1 out of 10 things in there that's untrue, some people get mad just about that and start attacking others. And then that can be used against you. So considering you're not a PR professional or an attorney, be careful what you say on social media when addressing anything that could be a civil or criminal or a domestic issue that may end up in court.
Glam tip of the week. If your reputation is under attack, the most glamorous thing you can do is protect yourself and not react emotionally.
What you post, what you say, and when you speak all matter. Emotional responses feel good in the moment, but they often backfire legally.
I've said it before and I'll say it again. Document everything. Talk to a lawyer, and remember, silence is not weakness. Public opinion moves fast, justice moves slowly, and the two timelines rarely align.
We have seen firsthand how this plays out, and soon you'll hear directly from a special guest joining us again who lived it beyond the headlines.
Hit that subscribe button and make sure to follow us. And if you've got a question for Let's Get Gritty, leave it at the comments or send it to podcast@antonianmiranda.com.
Thank you for listening, and we'll see you the next time on the Glamorous Grind.